Welcome to today's session on the legal principles of students' free speech. Our focus will be on understanding the First Amendment as it applies to educational settings. We'll navigate landmark Supreme Court decisions and grasp the implications of those court rulings in our schools and universities. Let's start with the basics. The First Amendment protects the right to freedom of speech, religion, press, assembly, and petition. In educational context, this primarily concerns free speech. But what does free speech mean for students in K-12 and higher education? And how do court decisions shape those rights? The first case we'll look at is Tinker v. Des Moines Independent Community School District, 1969. Imagine you are an educational administrator in the late 1960s. The United States is deeply involved in the Vietnam War, a conflict that has become increasingly controversial and divisive. Across the nation, protests and demonstrations are a common sight, not just on the streets, but also on college campuses. It's a time of strong political opinions and heightened activism, even among the younger generation. Now, let's reflect on the society we have now in the 2020s. Does it sound familiar? In the 1960s, there was a group of students in Des Moines, Iowa. Those students, including siblings John and Mary Beth Tinker, are deeply moved by the ongoing war and its consequences. They decided to make a statement, not through loud protests or disruptive acts, but through a simple, silent gesture, wearing black armbands to their schools. Their goal is to mourn the dead on both sides of the Vietnam War and to advocate for a Christmas truce. Word of this planned protest reaches the school administrators before it happens. When the school principal became aware of the plan, he warned the students that they would be suspended if they wore the armbands to school because the protest may cause a disruption in the learning environment. Despite the warning, when John, Mary Beth, and their friends wore their armbands to school, they were suspended. This is not a story of rowdy rebellion, but of quiet, symbolic protest, a type of expression that does not interrupt classes or incite disorder. Yet the students find themselves at home not because they disrupted a lesson, but because they dared to express their views. The Tinker family decides to sue the school district. They argue that the suspension violates their First Amendment rights. In a 7-2 decision, the Supreme Court's majority ruled that neither students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court ruled in favor of the Tinker family, acknowledging that school officials could not prohibit students' speech only on the suspicion that the speech might disrupt the learning environment. In order for the state, in the person of school officials, to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. Here, the Supreme Court is reminding us that school officials, as representative of the state, have a responsibility to uphold constitutional rights. This includes the right to free speech. As educational administrators, you are effectively the state in your schools, making decisions that can impact the students' constitutional rights. The key point here is the standard for justifying and prohibition of student expression. It's not enough to restrict speech simply because it's controversial or may cause discomfort. As administrators, your decision to limit speech must be grounded in something more substantial than just avoiding controversy. In practice, this principle means that as an administrator, when faced with a decision about limiting student speech, You must critically evaluate whether the speech genuinely disrupts the educational process or violates the rights of others. Here is another quote from the court opinion. The vigilant protection of constitutional freedoms is nowhere more vital than in the community of American schools. The classroom is peculiarly the marketplace of ideas. The nation's future depends on leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. The metaphor of marketplace highlights the role of the classroom as a dynamic space for diverse thoughts and opinions, similar to a marketplace where different ideas are exchanged and debated. This part of the quote advocates for a democratic approach to education, where truth and knowledge are derived from a multitude of perspectives rather than a single authoritative source. It implies a responsibility for school leaders to encourage a pluralistic and inclusive educational environment where multiple voices, perspectives, and ideas are not only tolerated but valued. The Tinker case is about a silent gesture as forms of student free speech. The students in the Tinker case wore armbands as a silent protest against a government policy or social issue. What are other examples of silent gestures as forms of student free speech? Pause for a moment and see if you can think of some examples. Here are some examples I have. Mirroring professional athletes, student athletes may kneeling during the national anthem to protest social issues such as racial injustice. Wearing t-shirts, pens, badges, and other items with advocacy messages is another form of silent speech that students may use to express their views on a wide variety of political, social, environmental, or other causes. As long as student expressions, such as wearing t-shirts with advocacy messages, do not disrupt the school environment or contain obscene, vulgar, or illegal content, school administrators cannot suppress those expressions, even if certain expressions like wearing advocacy t-shirts make some people uncomfortable or lead to complaints from students or families. School administrators generally cannot suppress those expressions solely on those grounds. The key legal standard, as set by the Tinker case, is whether the expression causes a substantial disruption to the school environment. Discomfort or disagreement alone does not typically meet this threshold for restricting student speech. School administrators are encouraged to navigate those situations by balancing the free speech rights of students and maintaining an inclusive and respectful educational environment. Substantial disruption means a significant interference with the normal activities of a school. It can include, first, interruptions to the regular teaching schedule, such as very loud or disruptive protests inside a classroom that prevent a teacher from conducting a lesson or students from focusing on their work. Second, threats to safety. This means any expression that creates a threatening environment, like speech inciting violence or physical altercations among students, would be considered a substantial disruption. Third, impeding other students' learning. If an expression, such as a large-scale protest in a school hallway, prevents students from moving between classes or accessing educational resources, it will be disrupting their ability to learn. Fourth, disturbances in school activities. Expressions that significantly disrupt school events, like sports games or assemblies such as protests that holds the event or prevents its intended purposes from being carried out, would fall under this category. Moreover, the substantial disruption must be real and material, not just a fear or anticipation of disturbance. To legally restrict a student's speech, a school must demonstrate that the student's expression caused an actual, significant disruption to school activities. Imagine a student wearing a t-shirt with a political message to school. Some staff members worry this could lead to heated arguments or fights, but no such incidents occur. The student goes about their day peacefully, attending classes and participating in school activities without any issues. In this case, it's not sufficient to restrict speech based on a mere assumption or fear that it may cause a disturbance in the future. This distinction ensures that the decision to limit speech are based on concrete evidence of disruption rather than speculative concerns. Here is a recent example. Imagine you are a school principal at a school football game. One of your students shows up with exaggerated eye black under his eyes, a common sight in sports. But this act is seen as blackface by some and leads to his discipline. Here is where it gets tricky. The student argues it was just a show of team spirit with no intent to offend or disrupt. According to the letter issued by Foundation for Individual Rights and Expression, also known as FIRE, the school principal summoned the student and his parents to a meeting where they were told that the student was suspended for 2 days and banned from future athletic events for wearing blackface to the football game. The key is that the principal did not indicate that anyone complained about the student's face paint or that it caused any sort of disruption. Similarly, the suspension report says only that the student painted his face black at a football game and lists his alleged offenses as offensive comment intent to harm. The principal did not provide evidence that the student's face paint caused a disruption, let alone a material and substantial one, at a football game or at school afterward. This real-life example challenges us. How do we, as administrators, navigate the fine line between maintaining respect and upholding free speech? It tests our judgment in distinguishing between what's truly disruptive and what may just be a misinterpretation of a student's harmless expression. It's a reminder that our decisions should be guided not by personal views or potential misunderstandings, but by the constitutional principles governing student speech. Here is my question for you. Consider a recent event at your school or university. Would it pass the Tinker test for permissible student expression? Please leave your comments below. Thanks for watching. I'll see you next time.